Thank you very much, Professor Kelly. I should say David is my cousin and not my brother. I'd be very proud if he was my brother. Thank you for the honor of asking me to speak here today. I'm very pleased to be here, not only because I come from that medical dynasty, but also because I'm a Scot by blood. Although I must admit, having been born and raised in Oxford, that blood's been thinned out a bit by Sassenach. I begin by reading to you a letter which was sent to me in 1988 by a solicitor after the completion of a case I'd been involved in. He wrote as follows: "I'm grateful to you for your efforts, and I should add, brilliant result in this case, achieved under the most trying circumstances. Two practical points arise. First, as you know, we were faced with no alternative but to instruct at the very last moment Dr. X. The principal reason being, which I think you'd better spell out in your opinion, that the expert witness we had chosen initially had become utterly unreliable. He had delayed 3 months in preparing a report. He in effect retracted his opinion given at conference. He indicated a clear unwillingness to attend court. He refused to do any research based on the statistics which were likely to be the deciding factor. He refused point blank to stay after giving evidence and lost his power of lucid speech 40 hours before the trial was due to begin." Well, that was one of the bitter experiences of my early career at the bar, but I read it out just to remind you that things can go terribly wrong when it comes to medico-legal litigation. My old clerk remembered hearing, when he was a boy clerk in the 1930s in the Temple, overhearing a senior QC shouting at a solicitor, "Get me an expert witness!" And the solicitor rather shyly saying, "Well, but who shall I get?" And the QC saying, "I don't care who it is, as long as he's got white hair and gold-rimmed glasses." That was the way of the world in those days, and there were many what they called hired guns who would pontificate 1 week in court on gynecology and on the next week in court on another case on neurosurgery. They were interested in expert opinion work more for the benefit of their bank balance than to the interests of justice. Of course, if you have no direct personal experience of what you're asked to give an opinion on for the purpose of litigation, it can be something you ought in conscience to refuse. That does not mean that a qualified expert is unable to give evidence of an expert kind on matters which he hasn't got direct physical or personal experience, but it's something you should always bear in mind. I remember a colleague of mine telling me about the 80-year-old surgeon whom he'd called to give evidence the week before, and he was asked predictably, "When were you last in the operating theatre?" And the 80-year-old replied, "Last week," which rather stunned counsel who was cross-examining him. My colleague asked the old man afterwards, "How come you were in operating theatre last week?" And he said, "Well, I know they're always going to ask me that question. So before I'm called to give evidence, I always ring up a friend who's still operating and ask, could I come and observe the operation you're conducting so that I can answer that question in that way?" The question that arises, first of all, for expert opinion evidence is, whose expert are you? As an expert witness, you will, of course, in a litigation in this country, appear either on behalf of the claimant or the defendant in a civil trial, or for the prosecution and defense in a criminal case. I say you appear for them, and thereby lies a pitfall. When you're thus enlisted, two ideas may at once present themselves. Firstly, that the party that enlisted you is in some way your client or customer, and secondly, that since the litigation process in UK is adversarial rather than inquisitorial, that you're being paid to take the side of one party against the other, and that your job is to fight one corner against the other. Both these ideas are, in the purest sense, wrong. I hope you'll forgive me, I'm going to hurry a bit because I've got quite a lot to cover in the time I've been allotted. What Lord Wolfe's civil procedure rules expressly state is that the expert witness owes his overriding duty to the court and not to one side or the other, quotes, regardless of the exigencies of litigation. That means basically regardless of who's paying you. Rather piously, this means that your duty as an expert witness is owed to truth and justice rather than to an individual side or cause or institution. Contrast the independence or otherwise required of a barrister. A barrister is in a real sense a sort of prostitute. His services are for hire, and when he's hired, his job is to advance his client's side of the case, to expose weaknesses in the other sides and highlight the strength of his own client's case, and to challenge and put to the test all the evidence. That we do as forcefully as we can, consistent with honesty, whenever allowed by the rules of our profession to make up defences or invent cases. But of course, that is not your role as an expert witness. And you have to bear in mind, and this is another pitfall, that there may be instances when it's quite clear to you that the opinion you're about to give is the one that the side who enlist you do not want to hear. Your opinion is, in other words, unfavorable. If it's diligently researched, honestly held, and impartially presented, you have, of course, absolutely nothing to fear. But you must not shrink from delivering that opinion honestly, even if it is exactly what your client doesn't want to hear. You must at all times be careful not to allow your opinion to be colored by either sympathy for the client or patient, or dislike or distaste for the defendant or the doctor or surgeon who has made a mistake, perhaps of which you strongly disapprove. The fact is, you must in all cases remain truly independent and impartial. I know that Lord Clark, who was Master of the Rolls and is now a Supreme Court Justice, in giving a lecture that I heard once, said that in his view it would be much better if any expert witness who's enlisted should not be told on which side of the case he is being asked to report, because it is such a human tendency to fall into the trap of favoring whoever you know has asked you to give an opinion. Please do try and avoid that, and don't be a hired gun of the kind that I mentioned earlier. When it comes to the hired gun who will give an opinion of the kind that he's asked to give, they're almost a disappearing breed now, not quite disappearing. I have to say that in particular in psychiatry there are one or two supposed experts who are notorious for always telling their client, in particular defense insurance companies, what they want to hear. But the judges, perhaps you'll accept this from me, judges and some of the lawyers are quite clever people, and those hired guns tend in the end to get rumbled. I say judges are quite clever people. I remember the story of F.E. Smith, the famous barrister who became Lord Chancellor, Lord Birkenhead. He was the cleverest man in England, so it was said, and also the rudest. And on one occasion, he'd made a point in the Court of Appeal in front of the three judges when he was appealing a case from below. And the senior judge in the middle thought it was rather a trite and trivial point and said, "Mr. Smith, please credit the court with some intelligence." To which F.E. Smith replied, "I'm afraid that's the mistake I made in the court below, my lord." So, impartiality is key, and independence is also of crucial importance. There are numerous perils if you forget those absolutely crucial principles. Let us say you've given your opinion in a civil case. You'll know then that if it goes to court, it'll be in the full glare of publicity. The gutter press will be there if it's a rather scandalous case or one in which serious events unfolded of public interest. I often think that there is a difference between the public interest and what the public are interested in, but nevertheless, civil litigation tends to hit the headlines sometimes. And if you've given an opinion in a civil case, you've got to remember this. One, your opinion will be relied on for the pleaded case, which sets it out in the first place. Secondly, it will be exchanged with the other side's expert reports. Thirdly, it will form the basis of negotiations, if any, towards a settlement. Fourthly, it will, in respect of the quantum of damages, inform the lawyer's views and the judges of the appropriate level of damages. And finally, if there's no settlement, it will form a central and important part of a battle in court. And the consequences of that are obvious to you all, I'm sure. The expectations of each party, based on expert opinion, will be high. The stress and distress attaching to the process of litigation, whether you are a defendant surgeon or an injured patient, are perfectly obvious. And sometimes the publicity which attends these cases fought out in court can be very painful, not just to the claimant or the surgeon, but also to the experts who give evidence. In a contested trial, always remember that ambiguities, inconsistencies, and plain bias have a habit, as I've already said, of becoming exposed. And an opinion which is a bit less than totally impartial has a habit of coming back to haunt you when it gets to that stage. What do you do if on the way to court or shortly before the case you realize that your opinion is wrong or you've changed your mind in one or another important respect? Well, obviously at that point you'll have to weaken and back down at a late stage. Alternatively, it will lead to a small settlement, perhaps where there should have been a larger one on behalf of the patient. Or worse still, if you don't back down before the actual day in court, you may cut a very sorry figure in court, defending the indefensible, for example, and being, as you all fear, I know, cut to pieces by some smart aleck barrister. Worst of all, of course, and this is a pitfall which is real but extremely rare, an expert who's given a thoroughly partial, biased, and inappropriate opinion can, in extreme cases, be both castigated by the judge publicly and, in certain circumstances, ordered to pay wasted costs. The famous case of Phillips versus Symes in 2005 is an example where the judge ruled that the opinion of an expert psychiatrist witness that a testator, someone who's making a will, had not been of sound mind at the time he made important dispositions, that opinion the judge found had been given in flagrant and reckless disregard of the expert witness's duty to the court and had unjustifiably caused meritless and expensive litigation to be pursued. He ordered that expert to pay a very large chunk of the costs of the case. So, keep calm though. That's an extraordinarily rare event and would require extremely bad conduct by an expert. But in the face of that sort of worry, please be calm, don't be alarmed. In every civil case, an adversarial English system, there'll be two sides to the case. I've, in medical law especially, heard two perfectly distinguished, eminent and independent experts give diametrically opposing views from the witness box about the merits or otherwise of what had happened in the given case, and at the end the judge prefers one to the other. Don't fear. The fact that your opinion is not preferred does not mean there'll be a great hue and cry or that you'll be vilified in the press. The simple point is this. In professional disciplines, there are difficult areas, of course there are, where expert views will differ markedly on grounds which are at least arguable and are advanced with complete sincerity. At the end of this, if your opinion is the one that is not preferred, that's considered a perfectly reasonable situation, and the idea that you'll be forced into retirement with shame over your head is generally completely absurd. Second, or next pitfall or peril of expert opinion evidence is, of course, the gulf between scientific and legal thinking. In the civil courts, the legal concept of proof is extraordinarily different from the scientific concept of proof. The judge has the luxury of deciding what the right answer is on the balance of probabilities. And that, of course, is alien to you scientists who deal in scientific certainty. So you'll have to get used to, in giving expert evidence, to dealing in the probabilities. What was more probable than not? And the concomitant of that, in legal terms, is that an expert witness, possibilities are not enough for the law. Of course, there will be cases where possibility is the highest you can put it, and other mechanisms, for example, of causation are at least equally possible, in which case you will have to say, I can't get into the realm of probability because I simply don't know. There are 2, 3, or even 4 possible causes for this disaster. So remember, it may seem like tiresome semantics, but if scientific certainty were required in civil litigation in our system, I think it would be very, very few injured parties who would ever succeed in a case. Remember that gulf, that probabilities are what go to the heart of civil justice in our country. I come to the next pitfall, pressures from lawyers. You will all know, perhaps, who've ever done this work, that the lawyers who are on the side that you are finding yourself may appear to try or be trying to persuade you to change your opinion in some way to make it more favorable to their cause. You must, of course, resist all such blandishments, however forcefully or brilliantly expressed, unless you think what you're asked to do or say is entirely reasonable and accords with what you mean and what your opinion truly is. These efforts may be subliminal and subtle, or they may be quite direct. But in certain circumstances, the lawyers may be asking you to do something which is entirely reasonable. For example, you may have used expressions such as might have, or could have, or possibly, and the lawyer will say, look, if that is the highest it goes, we can't win this case. Can you tell me whether this or that is more likely than not, is the most probable? And the lawyer is perfectly entitled to ask you that, and if it is indeed possible for you to translate what your opinion is into those terms, then of course you don't have to shrink from doing that. Don't automatically dismiss the lawyer's requests, because sometimes they're perfectly fair and reasonable. You must never, however, give an answer which doesn't accord with your true opinion. The next pitfall is your own jargon, scientific language, your failure to communicate your expertise, And that is a very, very central part of the expert witness's job. You not only must have the relevant learning and experience, but you're only of value to the system of justice to the extent that you can provide an accessible and intelligible exposition of that learning and experience, and that applies as much in your written reports as in your oral evidence. Two major problems beset the imparting of expert evidence. The first is that gulf between scientific and legal burden of proof or standard of proof, probability versus certainty. And the second is the difficulty of getting across complex scientific material in a way that lay people, and judges and lawyers and clients, patients are lay people, can readily understand. The general run of lawyers and judges, you will find the scientific knowledge is generally very low. Like me, so many of the older generation of judges and lawyers studied a lot of Latin and Greek and not a lot of science. But the fact is, they're usually quite intelligent people. So put yourself in their shoes and attempt as best you can to translate some of the more complex scientific issues into readily intelligible language for their purpose. And above all, do that if you're acting on the side which represents a patient. Do that for the lay client. Imagine the fog of bewilderment in which the poor injured patient sits when he hears scientific terms whirling around his head, none of which he understands at all. And he or she, the patient in that sort of situation, is the central and most important person in the end, because it's they who have suffered or allegedly suffered and need redress. Communicate with the lawyers clearly and with the lay clients clearly, and take advantage of conferences to make sure the lawyers understand what you're saying. Try to inform them and even fascinate them in what you're explaining. And indeed, one of the great compensations of my career, which has been stressful, and which my wife told me recently, if I hadn't agreed to retire age 72, the divorce petition had reached paragraph 963, that the lack of evenings and weekends, and you all know what a life is like that, one of the compensations has been the fascination of learning so much about so many different areas of medicine and surgery. So, tread carefully between the two extremes, one with crediting your audience with too much intelligence and knowledge, and the other which appears to treat them as slow-witted or stupid. Another exchange between F.E. Smith and a judge. The judge was exasperated because F.E. Smith seemed to be making rather a simple point. "Mr. Smith, what on earth do you think I'm here for?" To which F.E. Smith replied, "Far be it from me to ponder on the unfathomable workings of Providence." I wish I'd known him. He used to take a walk after dinner. He lived in St. James's. He used to take a walk after dinner in St. James's. And although he wasn't a member of the Athenaeum, he used to call in at the Athenaeum Club to have a pee on his circulatory walk each evening after dinner. And you'll know the Athenaeum, some of you. Huge Doric columns with wonderful capitals on them, a huge marble entrance hall, massive Greco-Roman temple appearance. And he used to walk up the steps through the great marble columns across the hall into the gents, have a pee and leave. And the members were becoming more and more irritated by him. So they asked the secretary to beard him and stop him. So on the fateful evening, the timid secretary tapped him on the shoulder as he was leaving, having had a pee in their club. Said, "Excuse me, Mr. Smith, but are you a member of this club?" To which F.E. Smith replied, "Oh, you've got a club as well, have you?" I come now to one of the... I wish I'd said that. I come now to how to conduct yourself in court. These suggestions are born of bitter experience, and I know sometimes the expert facing a judge or other barristers finds it a daunting experience and has all sorts of anxious fears about what may transpire. Can I just make a few sensible suggestions born of bitter experience? They're these. One, when you're going to court to give evidence and you're going to be called to the witness box, walk up to the witness box confidently, not timidly, because body language helps right from the start, as barristers learn early on. Always speak clearly and don't mumble. These are obvious. Next, when asked questions, answer them clearly in a loud and firm voice. Don't pause for thought unless you need to. If you do need to pause for thought, for goodness sake, do so, because it's much better to think clearly and carefully before answering than just give the first answer that comes into your head. Next, if the question is ambiguous or badly phrased or you don't understand it, always ask for it to be put again, because you can say quite clearly, I'm afraid I didn't follow that. And if the question doesn't make sense, either because it is indeed nonsensical, or because counsel has clearly misunderstood the whole concept, or because he's used the wrong terms, or whatever the reason is, and those things happen, of course, quite often, just say in terms, I'm so sorry, I'm afraid I can't make sense of your question. That way you'll put the barrister back on the wrong foot, and you'll put yourself back on the right foot. Don't try and answer a stupid question, because it'll tend to get a stupid answer. Here's some more basic points, which I think are very helpful to an expert in court. Be sure to correct early on, at the earliest possible stage, any mistake, error, or misunderstanding that you find you've expressed in your own written report. Do that before the other lawyer picks them up. Tell the judge straight away, at page 4, paragraph 6, I want to correct something which I shouldn't have written, I made a mistake there. Secondly, don't show off and grandstand. Don't leave that to the lawyers. Thirdly, don't underestimate the intelligence or insight of the barristers or of the judge, but be alert for their failure to follow or understand what's going on. Next, answer only the question you're asked. Don't attempt to second guess what the lawyer is getting at. Often, it isn't what you think he's getting at, isn't what he's getting at, and often if you try and second guess him, the judge will begin to think you're being partial and trying to fight one corner rather than being truly independent. Use so far as possible ordinary language and avoid excessive or technical jargon. Show polite deference to the judge, but not sycophancy. The Uriah Heep syndrome tends to go down badly with modern judges, although there are still one or two who you might spot who like to be crawled to, and if you do spot it, crawl away. If a good point is made against you in cross-examination, and you feel it is a good point, for goodness sake, say so. There's nothing worse than an expert who fails entirely to back down in the face or to accept a perfectly good point that's being made. And judges will spot that instantly. Finally, in this list, don't make jokes. Leave that to the judge. The barristers do try and make jokes. They have to be careful about it because some judges think it's their sole right to make the jokes. I remember Melford Stevenson, some of you may remember him if you're old enough, a vicious and difficult judge in the High Court who endlessly made jokes, always cruel ones, usually at the expense of counsel, sometimes even at the expense of witnesses and of plaintiffs. On one occasion I was in Reading Crown Court in front of that dreadful old judge, and there was a pile driver going on outside court. You know, they said thump, thump, like that. And the judge was becoming irritated, and finally he said, "What is this infernal noise?" And there was a stage whisper from the well of the court, "One of your sentences being carried out, my lord." Now, needless to say, we all laughed, but the judge didn't laugh. He was the man allowed to make the jokes. Cross-examination, how to cope with it. This is another of the major pitfalls that expert witnesses face. It can be daunting, but I'd emphasize the following points. I know I'm taking everything very quickly, but time rushes on, doesn't it? The opposing barrister may be formidable or bumbling, and appear to be formidable or appear to be bumbling. Don't be lulled into a false sense of security, and don't jump to the conclusion that he's some terrible ogre. Secondly, if you've mastered your scientific expert case, remember that he may have done as well, or he may not have done, and both are quite alarming. The barrister may use guile to trap you. The classic route is to ask you a series of fairly easy-going questions without you noticing where he's leading you, and finally spring the trap on you at the end, which you had been lulled into a false sense of security about, and then a flaw in your opinion is horribly revealed. Don't let that catch you out, and the way to avoid it being catch out is be well aware before you begin of the strengths of the other side's case and what they're really driving at. If you've prepared that thoroughly and you still hold to your own opinion, and you will have considered the other side's position extremely carefully, then you should have nothing to fear. So be thoroughly prepared and think very carefully about what the other side are saying. Don't show contempt for a reasonable point. Always watch the judge and his pen because he's taking a note normally in longhand. Don't ever lose your temper, even if counsel does. Counsel, we're usually advising our pupils, if you lose your temper as a barrister, you tend to lose the case, and that applies to an expert as well. Don't be put off if the barrister is getting angry or tetchy. He may be doing it as a tactic, or he may just be a bad-tempered fellow. But if you can remain calm and well-mannered, your opinion will come across much better. If you need to back down, that's something that often worries experts. What if you do need to back down? What if you suddenly realize on the way to court in your Rolls Royce, or in my case on the tube, or whatever it is, if you realize, oh my God, I think actually I'm wrong, and I've got to back down because I don't think any longer I can defend the position I've taken hitherto. Now that would be an honest situation to be in. And as a truly impartial, independent witness, if you are in that position, you must act on it. And it does happen sometimes. For example, you may have written an opinion entirely on the facts as presented in the factual witness statements on the side you're enlisted on. Let us take an easy example, an obstetric case where there's been a terrible disaster during labor. On the one side, you will have statements from midwives and doctors who were part of the labor management. They will give a version of events which in their minds may be entirely certain and very dogmatic, and you might write your opinion as an obstetrician, none of you here of course are, on the basis of those facts. Remember, whichever side you're on, there'll be another set of facts, because the other side's witnesses a fact. In the case of an obstetric case, the mother and the father, and perhaps the mother-in-law or the sister, whoever was there, will have their version of the facts. And it may be that it's suddenly established quite clearly that one side or the other's version is not right, and that you've depended on it to the hilt for the opinion you've given. And if you recognize then that I've been wrong, I must no longer pursue this, you must tell the lawyers immediately. Worst of all, let us assume it happened when you were already in the witness box. Again, the department of utter candor is where you must be. There is no profit at all to anyone, least of all the expert, in going on in the face of something where actually you've changed your mind. And you have to face the consequences. Explain why, say that you are, in the circumstances, no longer able to support the case that you had hitherto supported. And we hope that if and when that happens, you're doing that before the trial has begun. Dealing with questions from the judge is another tricky one for everyone. I think that the judge's questions are sometimes very misleading. Can I tell you why? They may sound dispiriting or even alarming or even very critical, but don't weaken or ever despair when the judge's questions appear like that. Sometimes it will be because he's demonstrating a clear failure to have understood the whole central point of the case. And I have encountered that. I remember one High Court judge, we were dealing with a case of preeclampsia, and on the fourth day he said, "Remind me what BP stands for again, will you?" And that was the fourth day. We realized he hadn't understood blood pressure even from the very beginning. So this does occasionally happen. If you realize that, and his questions demonstrate this, try politely to put him right in politest possible way. Sometimes, by contrast, the judge's questions may be quite encouraging and make you feel quite buoyed up. Oh, he got this, he's on my side, he understands me completely. Don't be too impressed with that, be glad of it, but remember this. Sometimes the judge is simply putting you to the test. Some judges will challenge both experts in the same quite hard way because he's testing out their opinion to see whether it stands up to the views he's made of the case. Stay calm, stay polite, and give the clearest possible answers at every point. And remember, even if the questions sound alarming and hostile, he probably hasn't reached a concluded view yet. In fact, he shouldn't have until the end of the case. So you're still in there with your opinion riding high, and you're entitled to stick to it, even if the judge seems to be trying to unseat you from it, unless his questions expose a flaw in your own view, which you recognize and accept. So, remember this, some barristers get quite tetchy and cross, but the art of cross-examination is not the art of examining crossly. And the truth is this, that it's better to be calm and polite at all times, because that way you get everything across so much better. You will, some of you have heard of the removal of the immunity of expert witness from civil litigation. It is true that expert witness used to be immune from being sued by an unhappy party who lost a case. That is no longer so, but the fact is this, if your opinion is diligently researched, honestly held, and impartially presented, you have literally nothing to fear from any suggestion that you might be sued by the unhappy litigant whose case was lost at the end of it. The facts of Jones against Caney, in which immunity was removed, were most extreme. Indeed, the opinion the expert had written had said that this witness was suffering from PTSD, and the whole case had been built on that. In the joint report of experts, the given expert had signed a report to the effect that the claimant was not suffering from anything at all, but was basically a lead-swinging fraud. And so there were the two opinions from the same expert. In that case, it was held that that expert had been in such flagrant breach of their duty of independence and impartiality that they should not be immune from being sued. Don't be afraid, don't be deterred by that case or its outcome. Such outcomes, such events will be as rare as hen's teeth. And indeed, the courts are very conscious that in every civil litigation case fought in court, there's a winner and a loser. And they're obviously going to be quite sure that these cases won't, except in the most extremely exceptional circumstances, ever be litigated again by somebody suing the expert. I just end on a cautionary tale. The witness who was asked, "But are you sure? Are you sure about that?" And he replied, "Yes, but I couldn't swear to it." And of course, he had just sworn to it in the witness box. I remember the story. I must end on this because I know my time is up. It's nothing to do with being an expert witness, really, but perhaps it is. The case concerned a collision at sea. And the issue was whether the ship that had collided with the other ship had no lights on at the time. And so the chief expert witness was, in fact, an old sea dog who'd been on watch on the BAUS during the events when the collision occurred. And the great importance of his evidence was that the collision was a terrible shock and a surprise, because the other ship hadn't got any lights on in the middle of the night. So he described how when he was on the deck on the watch, he said, suddenly there was a terrible bang amidships. And the counsel said, "And what was your reaction?" Wanting some such expression, it was, "I was terribly shocked." And he said, "Well, you could have buggered me through my oilskins." To which the judge said, "Excuse me, I'm so sorry, I didn't catch what you said." And the barrister said, "He said he was a little taken aback, my lord." Thank you for having me.
James, thank you very much indeed. On behalf of the Urology Foundation, I would like to thank James Badenoch for a most informative, instructive and highly enjoyable talk. And James has very kindly agreed to stay on for another half hour or so. He will be on the TUF stand, which is just behind the registration desks, where he's very happy to take any questions or answer any points that any of you might have. He has also very helpfully provided a brief template that we have copies of that people can take away about how to go about medico-legal reporting. So that will be available on the Urology Foundation stand. Thank you very much, James. And while I'm here, if I may, just a couple of words to plug TUF, the Urology Foundation. Firstly, I wanted to pay thanks and tribute to Professor Kelly's steering of the Science and Education Committee over the last few years. John has been incredibly visionary chair of our SEC, and during his time, we have been able to add so many more new programs to the urology community to be able to bid into for grants and awards, and that wouldn't have been able without his vision. So thank you very much, John, for all your help over the last few years. And as John has exhorted some of you, do please consider applying to become either a member of the SEC or even applying to become chair. We will shortly be putting out a call for that, so please, do think about that. And finally, if you come and see us on our stand, there are a number of ways that you can get involved with the charity. We have Urology Awareness Month coming up in September, which is the month that we try and tell the public about urology and make them aware about certain conditions and diseases, but it's also a month where we would like you to engage with us in that task, but also engage with us in terms of fundraising, because it's only through donations that we are able to fund the work that we fund for you to be able to apply for those research scholarships and for those visits. So do come and see us. We'd be delighted to see all of you. Thank you once again for attending, and thank you again, a very big thank you to James for a wonderful talk. Thank you.